Legal mode, Colorado. Effect of PPO revocation on Frederickson's civil lawsuit against Thayer, Archbell, other defendants, and the county. Short answer, yes. The dismissal revocation of the PPO materially harms Frederickson's civil lawsuit, though it does not automatically dismiss it. The impact is indirect but substantial, especially on credibility, intent, damages, and claims that depend on fear, harassment, or retaliation narratives. Below is the precise court realistic breakdown. On 1, what a PPO revocation legally establishes and what it does not. What it does establish. A PPO revoked after rehearing establishes that a court has found one or more of the following. The claimed fear was not reasonable or not credible. The factual basis for protection was insufficient. The petitioner's conduct contradicted the need for protection. Prior assertions were overstated, misleading, or undermined by evidence. These are judicial credibility findings, even if not labeled that way. What it does not automatically establish. It does not automatically bar civil claims. It does not prove civil liability by itself. It does not trigger formal collateral estoppel across all issues, but courts absolutely consider it. 2. Direct impact on Frederickson's civil claims. A. Claims based on harassment, threats, or fear, major damage. If Frederickson's lawsuit alleges or relies on harassment, intimidation, threatening conduct, ongoing fear, need for protection, retaliatory behavior by defendants, then the PPO revocation is devastating. Why? A court has already found the fear narrative not credible. Video body cam evidence outweighed Frederickson's version. Subsequent conduct, chasing admissions, contradicts claims of victimhood. Defendants can argue, open quote, the same factual narrative has already been rejected by a court after an evidentiary rehearing. Close quote. That is powerful impeachment. B. Claims requiring clean hands or good faith. Many civil claims, especially against government entities, require good faith conduct, reasonable belief, absence of misuse of process. The PPO revocation, combined with harassment citation, admissions to police, false TRO service claims, supports arguments that Frederickson acted in bad faith, misused legal processes, weaponized protection orders. This undermines equitable claims, injunctive relief requests, some constitutional claims premised on being a victim. See damages and emotional distress claims. If Frederickson seeks emotional distress damages, mental anguish, fear-based damages, reputational harm based on alleged harassment, defendants can argue fear was judicially rejected, conduct was self-initiated, emotional distress was not caused by defendants, but by Frederickson's own actions. This significantly reduces damages exposure. 3. Impact on claims against the county, especially strong. Claims against the county, e.g., 1983, due process, failure to protect, conspiracy, retaliation, are especially vulnerable after PPO revocation. Why? Courts defer heavily to objective evidence, body cam, CCTV. PPO revocation shows the system did correct itself, undermines claims of systemic abuse or official endorsement of harassment. Harassment citation against Frederickson weakens claims of selective enforcement. Counties often succeed on motions to dismiss, qualified immunity, failure to state a claim arguments. The revocation strengthens those defenses. Number 4. Use of PPO revocation in the civil case. Procedurally, defendants may use the PPO revocation to support Rule 12b-6 or Rule 56 motions, impeach Frederickson's sworn allegations, demonstrate lack of causation, show alternative explanations for alleged harm, undermine credibility at deposition or trial. Even if not preclusive, it is admissible and persuasive. Number 5. Pattern evidence makes the impact stronger. In isolation, PPO revocation is significant. In context, it is much more damaging. Here, defendants can point to prior dismissed lawsuits, failed service attempts, statements about refiling indefinitely, coordinated TRO attempts with a roommate, police observed harassment, false legal claims to officers, PPO revocation after video review. This supports abuse of process defenses, vexatious litigant arguments, sanctions requests in extreme cases. Number 6. Likely practical outcomes in the civil case. Most likely effects: increased success on motions to dismiss or for summary judgment, narrowing of surviving claims, reduced settlement leverage for Frederickson, heightened judicial skepticism. Also possible: court limits evidence Frederickson may rely on, Court issues warnings about repetitive filings. Court orders focused discovery on credibility and intent. Unlikely after PPO revocation. Fredrickson prevailing on fear-based claims. Court crediting harassment narratives without corroboration. Injunctive relief against defendants. Number 7, bottom line legal conclusion. Open quote, yes, the PPO dismissal revocation materially weakens Fredrickson's lawsuit, especially claims premised on fear, harassment, retaliation, or good faith. While it does not automatically end the case, it significantly improves the defendant's position and increases the likelihood of dismissal, narrowing, or defeat of key claims. Close quote. In practical terms, the revocation changes the litigation gravity in defendant's favor. If you want next, I can. Map PPO revocation effects to specific civil causes of action. Help draft motion to dismiss or summary judgment arguments. Prepare deposition impeachment outlines using the revocation. Analyze how the harassment case further compounds civil exposure. Help structure a vexatious litigant or sanctions strategy. Tell me which direction you want to go.